selling real estate while there's an active probate case going on. Realtors, personal representatives, and heirs, this video is for you. And please remember to stick around to the very end for your pro tip. Hello everyone, my name is Joseph Radzwion IV, your trusted attorney with Radzwion Law, PLLC, and I'm a licensed attorney here in the state of Michigan that regularly practices probate law. In this video, we are going to look at what the probate court process looks like for selling real property or real estate when someone who's owned that property has passed away. Now, real property is typically something such as the decedent's residence or primary residence. It could be a rental property, a vacation home, cottage, farmland, you name it, any sort of real property or real estate. And this process will touch a little bit, at least on the procedure aspect, for selling a mobile home or a trailer that the decedent owned at their time of death. Real property or real estate is typically one of the bigger assets that an estate holds or owns when someone passes away. And that means certain things are going to occur, such as the court may require that the personal representative, that's the fancy word for executor in Michigan, the personal representative may have to be bonded before the sale of the real estate is allowed to proceed. The court also may require the personal representative to submit certain documentation showing who the buyer is, where the funds are going to end up, all of those certain things. But for the most part, this video is covering the general process that a vast majority of the probate courts follow here in the state of Michigan. What I'm about to describe to you also assumes two specific things. Number one, that there is actually an active probate court case going on, and that probate has been opened or someone has filed to open a probate estate. The other thing is that the court has, in fact, authorized an individual to act either as the PR or special PR or some other fiduciary capacity to accumulate the assets and sell them off. After these first two steps have been completed, the personal representative is going to want to obtain either a purchase agreement, sales contract, or some sort of written documentation showing the purchase price of the property, who's buying it, all of the things that normally would occur if property was being sold between two individuals that don't know each other. The next step would be that the personal representative takes that purchase agreement and attaches it to a petition to sell real property and has that form filled out or the petition filled out to submit to the probate court with the purchase agreement attached. There'll typically be a nominal fee such as $20 that will have to be filed with the probate court in order for them to accept the filing. The court will then set a hearing date for the judge to review the petition and allow any interested parties to file objections. I do have a video on objections that will shed light on how someone who doesn't agree with property being sold for whether it's the purchase price it's being sold for or it being sold in general. And that video touches on how an individual can let the judge know that they don't agree with what's going on. It will be in our probate law DE playlist. So what happens after the hearing? The court will typically, if there are no objections that have been filed, will approve the sale of real estate and issue an order granting the purchase price, the terms of the contract that have been submitted to the court, all of those things, and it will allow the sale process to move along. What about timing? Is a common question that I get asked from my clients that I assist when we're selling property in the probate court or with an active probate court case going on. The typical response that I tell my clients is that once we have a signed purchase agreement, it will take anywhere between 25 and 45 days before we get a hearing date and before the court will even look at our petition. Now, there are a couple factors that play into that as to why it takes so long. Sometimes it can be shorter, sometimes it can be longer. But remember, per the court rules, notice of a petition and a hearing date must be served at least 14 days before the actual hearing takes place, depending on how service occurs. But if you want to understand how more of the service and the notice rules work in the probate court, make sure you subscribe to the channel so that when that video is posted, you are notified. Click that notification bell, and that way you don't miss that video when it is posted. We will now get into our pro tip since you've stuck around to the end of the video. There are 3 things that a skilled attorney will file with the probate court and to help the probate process move forward with the sale. And those 3 things are documentation that lists the property's description very concisely. It can be attached to the petition that is initially filed. The court will want to see that. The second document will be some sort of documentation that shows what the value of that property is and how it compares to what the purchase price or what the property is being sold for at that time. There are a host of different documents that people use to show the court what the property is assessed at. Some are more reliable than others. The other thing would be once the court does approve the sale and writes an order saying, yes, you may proceed with the sale, there are specific title companies in Michigan, most of them will, and some realtors will require this document from the court. Rather than just a signed order, they will want a certified copy or a certified order from the court for the title company to do their processing of the sale. So it would be expedient to obtain a certified court order instead of just getting a copy from the court. A certified court order will go a long way in moving things and keeping things moving quickly. If you have real estate that is being probated and you have questions, feel free to get in touch with us today. You can do so by heading over to our website or giving us a call directly. And also, if you have more questions about how to open a probate estate, we'll leave videos on the screen here that you can click on and gain more information for that process. And then there's also, we'll leave another video that talks about some of the service requirements and what documents the court want to see in order for hearings to proceed smoothly. And we'll leave that on the screen as well. Thanks again for watching. We'll see you next time.